who we have on then after that is James Staines, who is our legal advisor in IFA and runs the IFA helpline, and we have Isabel Carr and Rosemary Isabel Lyons and Rosemary Carr from the PRAI as well, to answer any queries people may have. And just to put everybody on notice, the intention is that we record this tonight, and it will be uploaded onto the IFA website. So look, I'd ask people to be conscious of that when they're making their comments, maybe to keep their comments afterwards and questions as as brief as possible. So look, without any further ado, I'll hand over to Rosemary McDonough, our Farm Business Chair from Galway.
Okay, thank you, Chair. Thank you, Francie, and hello to everybody this evening. And as Francie said there, the turnout is really, really great this evening, and it shows the interest that there is in this subject. So I want to welcome James Staines from Staines Law, and again, thanks for taking the time to do this, do the presentation. And then to the girls, Isabel Lyons and Anne-Marie Carr from the Property Registration Authority of Ireland, for taking the time out of hours to come online to an IFA event and to take questions. Thanks very much for your time. And also, I suppose, from the point of view of the from Farm Business, we have a seat on the customer focus group with the PRAI. So quarterly we have meetings. So by having a seat on that committee, we're able to bring queries to the table and hear the discussion that there is with all the other stakeholders that are on that customer focus group. And I have to say the PRAI are very obliging and accommodating in the work that we have done and that I have been involved in over the last couple of years and with IFA. So I suppose the key point of coming to this, the change in the law or the deadline, so that there will be a change on the 30th of November, that the new Act, the 2009 Act, is coming in place. And I suppose there are a lot of queries and the time is running out. So IFA would have had a meeting with the Minister and have asked for an extension, we'll say, of this deadline. And that also we stress the need to adjourn the implementation of the 2009 Act. So we would be hoping that there may be some, changes there. But also from the point of view of, we'll say, the new law that's coming in, the new Act that's coming in from the 1st of December, that James Staines with the expert will go through in detail. But there will be some, I suppose COVID will have had some implications and have impacted on creating barriers to registration, and business and communications have been interrupted because of COVID. So people may not have been able to actively assert their rights away during the public health restrictions, and that may come against them in trying to register their right of way for their existing right of way that they feel they have for this new deadline. Now, we also feel that the 09 Act will further complicate the registration process by creating additional costs and stress for farmers. So look, for the vast majority of the landowners, there will be no difference after the 30th of November 21, so from the 1st of December. But for a small cohort of farmers, that there will be a few that will be impacted. And for those that are impacted, I mean, of course, this will be a big challenge, that they may have issues in trying to register their right of way. So I suppose on the back of those few comments, I'll hand it back to Francie, and I'll let the James Staines go through the technical issues. Okay, thank you, Chair.
Thanks very much, Rosemary. And look, we'll move straight on to James. James, you're very welcome. So the floor is yours, and you can start your presentation.
Just before you start, James, can I just ask everyone who's not speaking just to mute themselves, just as there's a bit of feedback?
No, sorry, I've unmuted myself there. Jackie, is my slide presentation showing up there, is it?
It is, James, yeah.
Great, that's fine, thanks very much. Okay, Rosemary, thank you for the invitation to this. As Francis said, we operate the IFA legal helpline on behalf of IFA members. We can ring and get a general legal steer, and traditionally, and certainly over the last year, more than a quarter to a third of all the calls we get in the helpline relate to rights away. And I think the people become very aware of this deadline at the end of November, which I will go through. I think, Rosemary, to be fair, you actually gave quite a good summary of the issues and that arise, and I hope I can add to it, but it was a very succinct summary of where we're at. So what I want to do this evening is just briefly review for people what rights away, and it's not just rights away, it's easements as well, which I'll go through. Because I think it's important that you know what they are, so you can identify them and see do they actually relate to you. And then I'll talk about how you register these rights away, and very important why you need to do these in light particularly to 2009 Act. And then I will try and explain the shift from the 1858 Act to the 2009 Act and how that impacts upon you and why this deadline has arisen. I would also hope, again, to echo what Rosemary said, this is not going to affect the vast majority of people listening here. And I see there's nearly 200 people have logged on at this stage. The vast majority of you, if you decide to do nothing about this because you've got better things to do during the summer, you've got harvest, whatever, to deal with, you're going on holidays or whatever, or it's just you long finger this and you decide this time next year you want to go and register right away, the vast majority of you will not be impacted. But as Rosemary said, there is a small cohort who, for a variety of reasons, ranging from COVID to the other landowners may not have the capacity to simply your change in farming practice, you may not have used the right of way for a period of time, will be impacted by that. So what I would hope out of this meeting, I'm not going to answer all your questions, and I really appreciate the two individuals from the PRA, Property Registration Authority, or Land Registry as I still call it, who will be able to deal with some of the more technical and practical questions that they see every day coming in with the application. So I think by the time the meeting is finished, you'll have a very good idea how this impacts upon you and what steps you may or may not need to take to regularise your situation. But I think on balance, it is important that you be aware of the rights of way issues and what you can do on that. Again, this is the downside of these online webinars. I frequently get asked most of my questions at the end having a cup of tea, and there will be room for questions on this. But if you do have any questions afterwards, there is the IFA legal helpline. You'll get the 1890 number on your membership card, and you can ring in with any queries, and we can deal with those in privacy as well, which may suit some people. So just to kick off there, what I want to talk about there is, again, what is the right of way, how do you require it, the ways to register it, and the impact of the deadline. Now, a right of way is, and I'm giving quite a simplified version here, is the right to pass and repass all times for day and night from point A to point B over another person's lands to access your land on foot, with or without car, vehicles, machinery, for either all purposes or for a specific purpose such as accessing a house or for agriculture. And that in broad terms, in non-legalistic language, is what it is there. All this legislation that we're talking about, the 2009 Act, the deadline, also applies to easements and various other rights, like the right profit upon to take grass or take turf and various things like that. But an easement, for example, is the right to go onto somebody else's land, to lay a cable to access a well, a pipe, a drain, or something like that. And also the right to go onto that land, repair, maintain, and obviously reinstate the land afterwards. So this isn't just about rights of way, and I think it's really important that everyone talks about the rights of way and the deadline. This is not just about rights of way; it's about easements. It's about other rights that you may have acquired under the various legislations. So I'm going to get slightly technical now, but it is important that you be aware of this. You'll hear this language of dominant and servient tenement. And just to be clear, that the servient tenement is the land. So if I have a right of way over your land to access my fields, I'm the dominant owner because I am accessing the land. The servient tenement because I access over your land. So the right of way must accommodate me at the end. So some third party cannot have a right of way over that laneway if their farm is further down the road.
James, where's your phone?
Sorry.
Will you ring Laura's number?
Ring it.
Sorry, James.
Sorry, if everybody
could
could
mute
sorry,
everybody. Yes. And yeah, because it's
Yeah, so James, you can unmute yourself there and we'll go again.
There again. Sorry, I thought some of the questions. So, and you can't have a right of way over your own land. So if, for example, you buy your neighbour's land over and you had a right of way over it, that right of way actually goes, and it's important if you sell the land on again. And there's issues about which becomes very legalistic. The rights must be capable of forming the subject matter of a grant, but the right to pass and repass, the right to lay cables always fall within that. What will be very common actually, which will become more relevant, is air grid ESB laying cables. They look for way lever easements, or wind farm or solar farm developers laying cables. So the next question is, how do you acquire these rights of way or easements? Firstly, by law, there are certain provisions where you may be entitled to get a right of way. And what they call, again, without being too legalistic, by express grant or reservation, which is just a fancy way for saying I give you a right of way over my land. Or if I sell land to you, I keep a right of way myself over it, and that's the reservation. And it's done by a straightforward deed of grant, which is a straightforward land registry form. And in essence, that says I own folio A, you own folio B. You're giving me a right to cross over folio B along the pathway or roadway marked 8B on the map attached here too. And again, the map, it is very important, is the map has to be marked by a surveyor or engineer. It has to be a land registry approved map. And the main difference between that and your ordnance survey map or your department maps, it has the specific coordinates on the top, which I understand they use to assist them in mapping it on the digitized system that they have. There's also an implied granularism. So if I sell you a block of land but forget to give you a right of way, there's an implied right of way for whatever the purpose of that land is for. So if you bought land to someone and they forgot to give you the right of way, which I'm sure the odd solicitor makes a mistake on that, you'll be entitled to an implied right of way. Or if I give you land between me and the road, there's an implied right of way over that for me to get out. And then the last one is by prescription, which is actually what causes most of these problems in terms of that. So I have to give you a little bit of history lesson now on the on this piece of legislation. So the rights of way have always been problematical going back to the 11th and 12th century, and they made various efforts to try and deal with it. But by the 1830s in England and the 1850s in Ireland, they brought this act in, which effectively said, if you've been using a right of way for more than 20 years, we'll pretend that you've been using it since 1100 something, and you can apply for it at that stage. Now it's 20 years over your neighbour's land, it's 30 years over state land, and 60 years over the foreshore. So if your land runs over the state land or forestry land, which may have been state land, it takes 30 years to acquire the right, and foreshore is obviously a lot longer there as well. Now, to be fair, the Act, the 1858 Act, and it's the English equivalent of it, was once described in a court case as being the most badly drafted piece of legislation, and most people would agree with that. It's very complicated. It's trying to do something that doesn't really do it properly, and it's very cumbersome. And to be fair, a lot of thought and effort went into the Land and Conveyance and Law Reform Act, and it tidied up an awful lot of bits and pieces. It tidied up legislation that we up to then referred to going back to the 1640s. So it was a very good piece of legislation. Now, to be fair, they tried to tidy up how you got your rights away in easements, and unfortunately, I think the legislators made an even bigger mess of it than was under the original Act, and they had to tidy it up again in 2011. So, and unfortunately, there are still quite a number of issues with it. And I have to say, I'm not sure that everybody has the answers to some of the questions that arise. I was watching a presentation done by the Law Department in UCC back in February. If you're really interested in this area, Google that. And there was the leading barrister on rights away, and there was a leading professor on property rights. And they were asking each other questions, and he didn't have the answers to how this deadline is going to impact upon certain aspects. Now, again, they're quite specific points, but most people won't be affected. But it is still a complicated area, and nobody has all the answers in terms of that. So what the 2009 Act did, it shortened the 20 years down to 12 years, 30 still for state and 60 for foreshore. It abolished the lost modern grant doctrine, which you needn't worry about. It allowed that you could only apply for your easement or right of way to be registered on foot of a court order, but that was changed in 2011 and tidied up. And then the 12 years now, you have 12 years to register from 2009. Now, the next thing is that I think it's a very important thing. If your right of way isn't registered, and there's a huge number of rights of way not registered, I would be curious if the land registry are in a position to say how many rights of way do you think are not registered in this country, because I've never quite worked it out, but I'm sure at least half of them must not be registered. But if you're not registered, they can be extinguished after 12 years. And I think that's very important for people to aware. If you're not using it, it's easier to extinguish them. Now, what I want to do, kind of moving on to onto more practical aspects, if you have a right of way, are you concerned, is there a right of way over your land, or do you have a right of way over the other person's land to access your land? There are a number of things you need to do before you worry about it. First of all, if the road is in charge to the local authority, so it's a public road, then anyone can pass up and down. So there's no need to worry about the right of way. Now, bear in mind, just because the local authority tar the road every now and then because it might charge you a few quid for it, does not mean it's in charge. But if you suspect that it is, you can go down to the local planning or the local roads department, and for a fee, they'll be able to tell you. You may actually own the laneway, and I've come across a couple of cases of this where people thought there was a right of way and wanted to register, but when we checked the folio, they owned the laneway, or they owned a large portion of it, so it wasn't such an issue for them. There may also be an issue that historically this was a public right of way, and it's quite hard to lose a public right of way, so you may be able to go back to that. And we have a couple of those where roads that might have run between 2 points before a bypass or something came in were public rights of way, and we've been able to assert their public rights of way and move on from there. I talked there that you could get you could get a right of necessity or an implied right, and Section 40 of the 2009 Act applies to that. So if you sold land to someone and they need to get out across your land, to access the road, there's an implied right. And if you sell land to someone and you forget to keep your right of way, there's an implied right for you to cross. So again, there's a number of issues there as well. Something a bit more complicated, and I think it's something that, to be fair, a lot of solicitors overlook, is when the Land Purchase Acts, which were all from the 1880s, 1890s, which were then subsequently used by the Land Commission to divide out the large estates. There is provisions within that if there was effectively within that land, if technically I owned the estate, but technically you were another person who might have owned a field and you had a right of way based on that, there's an implied right of way for you there as well. So again, if you're under pressure, if rather than looking at court, I think the lawyers, the solicitors you're instructing should look at that particular option. And I have to say, it's something I think an awful lot of conveyancing solicitors are not aware of. And it is certainly something worth looking at, because it might be a number of you out of a difficult. So I think they're all things to consider before you get too worried about going off and registering the rights of way under the 2009 Act or the Prescription Act. There are other ways of getting your rights of way other than that. But again, just to be clear, the bulk of the rights of way would have to be registered.
Sorry, James, you're on mute there again. Sorry, James, you're on mute there again.
There we go. Now, can you hear me now? Yeah, thanks. So the next question is, you decided that you want to register your right of way or register that easement that we keep talking about. And there's a number of ways that you can do it if those other possible scenarios don't work. And again, to emphasize, this is the way that the vast majority of the rights of way will be registered in the PRA. So the first one is you simply get your neighbour to sign the land registry form that says, you own that folio, I own this folio, and you're giving me a right of way to pass over the line AB. Within that form, you can add various additions to it about keeping gates locked, about repairing, maintaining it. All of those types of things can be tidied up. And also, if you're giving the right of way, you may say, well, you can only use it for agricultural purposes, or because you may not want someone building or developing on the land. And if that's what they've been using the land for the last 30 years, you're within your rights to do that. There's nothing stopping you negotiating with your neighbours for additional rights of way on that, but there's no automatic right or obligation on you to pay your neighbour to give you that grant or right of way. But again, there's nothing stopping them asking for it. The next way, if your neighbour won't sign that, or say, which is quite common, you're on a laneway, and there's 4 or 5 owners owning to the middle of the road on either side. What you then need to do is you need to get that right of way, that deed, that document, signed by each neighbour. And the way to persuade them to do it is that it tidies up their rights of way as well. And you may offer them a couple hundred quid for them to go to their solicitor to make sure that you're not ripping them off, and that often works. But you may have out of that laneway 5 people and 4 will sign and 1 won't. And then at that stage, you're going to have the next step to do is your next option is to make an application to the land registry called a Section 49A application. And as part of that, there's what I call a Form 68, which is just a detailed affidavit that sets out how you acquired the right of way, what you outline your lands, you outline the lands you've crossed over, you put the land registry compliant map in, and you set out the history of your dealing with the laneway. And the land registry will process that. They will raise queries on it, and if they're satisfied that you have, a right of way, they'll write to your neighbours, and let's be clear, they will always write to the other landowner. You can't just sneak this in through the back door. They will always write to the other landowner, and if they don't write back or object, in essence, they will then grant they will register the way. And I understand from the London that takes about a year is the average process time in terms of that. So that's the easiest. That's the next step to do. And we always recommend, if you have the other neighbours that sign the initial land registry form, get them to do that. And if you've got 1 or 2 neighbours won't do it, off you go and deal with it that way. Now, that can get very complicated. We're working with we're buying land for somewhere where they've had to go and register 13 rights of way over a laneway. Some of those people are dead, and there's other sections of the Act to make an application to register it that way. But it is a complicated enough issue, and there will be a cost to it if you go down that particular route in terms of that. Now, your last option generally, so you can do it from the onset if you want, is you can make an application to the Circuit Court to seek an order directing the PRA to register your right of way. And generally, you'll only go to court if your neighbour's objecting to it, or it's just been difficult, or it's actually disputing that you have a right of way, and that's where you go. But there's obviously the cost consequences of going to court, which can be quite substantial. So they are the 3 ways that you can, under the 2009 Act and the other legislation, register your rights of way. And again, as I said, that's where the bulk of people will apply for. Now, again, you can raise more detailed questions with the representatives from the land registry. But and I'm giving a very short summary, and they're probably raising their eyebrows at the brevity of this, and they probably say this is why there are so many queries raised by the land registry, which there are, and I understand there's about a 70% rejection rate because the forms are incorrectly completed. But the form you just give details of your land, the other person's land, a detailed statement of exercising the right of way. So you go back to, my grandfather bought this land in 1933, and he exercised his right of way up and down, and we did this, we did beef, we did sheep, we did dairy, we built the house, we did this, and my father took over the land in 1962. He kept doing this, he passed on, I took over, I've been doing this. This is our farm enterprise. the vet goes up and down, the milk truck goes up and down, the combine goes up and down. All of those points will be put in. The more detail, the better.
So we're looking for right away. Yeah. I don't want somebody exactly. I want somebody who wants to.
Sorry, James, you're on mute again.
Yeah, no. So I think when Jackie mutes everybody, I get muted there. So, so just be aware then of going to court is last resort, but it can be used. Now, again, what you need for that, again, we've gone through that. A large number of forms are incompletely or not dealt with, and they are rejected. And it's very important, the PRA does not get involved in the dispute between the landowner. So if you've applied for it and the other neighbour writes and says, these people do not have a right of way, or they have a right of way for agricultural purposes only, or whatever, the PRA does not get involved in that round, does not adjudicate in that, and will effectively say, look, this is not our problem, go off and sort it between you, or go to court and get a court order in terms of that. So it is. Now, one thing to be aware of, and this is a small point, it may or may not affect you, when you fill in the land registry form, the form 68, you are asserting that there are not claims made under other types of sections. And then if you apply for court at a later stage, you've cut off those options. So it's something you need to be very careful about, that you don't prejudice any other rights by going down that particular route, if that's to be the case. Now, you're probably sitting here going, why do I have to register my right of way? We've been using it for the last 20, 30, 40, 50, 100 years. Why do I have to go and register it? And this is, I think, a very reasonable question. And I think Francie asked me that question earlier today when I was talking to him. So bear in mind, up to 2009, if I bought land from you and there was a right of way, you simply gave me an affidavit that said, I and my predecessors have been using the right of way for the following reasons for this long. And that was an acceptance, a declaration of long use. And that was an acceptable way for standard conveyancing practice for your solicitor to buy the land, and everyone could sign off on that and everyone was happy with it. Now, unfortunately, rightly or wrongly, and I think this may be one of the unintended consequences of the 2009 Act, I'm not too sure, the way it is drafted, it now requires a right to be registered. So all the banks and the purchaser solicitors are now saying, we want a registered right of way. We're not prepared to accept that declaration anymore, because we'll have to go and register it, and we don't want to have to deal with all those questions ourselves. So the problem is that if your purchaser is borrowing money to buy your land, they will need to show to the bank, or the solicitor will need to show to the bank, that there's a registered right of way for them to access the land. And if they can't show it, the bank won't lend the money. There's an issue with some department schemes that you may need to show access in, and that can be tricky at times in terms of that. Also, if you transfer a site to a family member, or sell a site to someone, and they start building on it, they will need to have a registered right of way to access their land. And again, if the bank, they're cash buyers, that's fine, that's their problem. But if they're borrowing money, they will need to show a registered right of way. And frequently, that's where we first get involved, is the site was transferred, and then the house has been built up to first floor level. The son or daughter go off to get the money, and the first thing the bank or the solicitor asks, where's your right of way? And then, of course, they've had rows with the neighbours object to planning, and then the neighbours are very difficult about this. So this is why you need to sort these things out before you go off buying and selling. And that is the reason why you need to get your right of way registered. In terms of that. There's another practical aspect, because it is deadline. If you don't register your right of way, and for whatever reason you may have acquired rights under the old Act, but you haven't been using the right of way for the last couple of years, or the person who owns the land you cross is under what they call an incapacity, dementia, or stroke, or something like that, you may not be able to register under the new Act. And this I think is the really critical point. And I'll just talk about that now on the 2021 deadline. Okay, so skip down to the slides there. So sorry, just again, I think I missed the slides. So that's why you need to register for that, and that's why people are asked to register it. And also, if you don't register, you may lose it under certain circumstances. Now, as we're coming to the nub of why this webinar is happening tonight, there's a deadline in November 2021, and you may remember one of the previous slides we had where they changed the deadline, which was a lot shorter, was pushed out for 12 years. And the reason that was is under the old Act, you could have acquired your rights, but they're now saying after 12 years, it doesn't matter what rights you had under the 1858 Act. It doesn't matter that your grandfather had been using the right of way. You can only now acquire your rights under the 2012 Act, or 2009 Act, and that's 12 years from the day up to the date you make your application. And again, as you can understand, for most people, you've been using your right of way for the last 12 years. You've been using it for the last 60 years. But if you make your application today, you say that at any time, I've acquired my 20 years and I'm entitled to be registered. And it doesn't have to be 20 years before you make your application. You could have, your 20 years could have, you could have clocked to 20 years up 5 years ago. And that's where your right actually locked in 5 years ago, or, you know, whatever. That's a slight difference between the old Act and the 2009 Act. You have to have been using it for 12 years before your registration. And again, most of you will have been using it for the last 12 years. But, and obviously, sorry, again, state and foreshore are 30 and 60. So what's the possible risks here? You haven't used the laneway for the full 12 years. You may have changed your farm enterprise and not had to go down there. You may have leased land on the other side and you had a more direct access to your field, so you didn't need to use the laneway. But that will change when the lease expires on the other land. The person who owns the land that you've crossed the right of way may have been hale and hearty, 10 years ago, but unfortunately they may now have a stroke or dementia or Alzheimer's, and they have no capacity. And the time doesn't run against individuals who have no capacity. So if, for example, the person who owned the land was perfectly fine up to 2009, they had a stroke, they went into a nursing home, they had Alzheimer's, you've actually only got 9 years against them, even if you've been using that laneway with their consent and approval and knowledge for the last 50 years. From the way this legislation is drafted, and this, my reading of it, is that you only have acquired 9 years because that lady or gentleman does not have the capacity. And this is where we see possible deadlines. And if I'm reading this wrong or there's other ways around it, I look forward to hearing what the PRA representatives have to say. And again, if you haven't been using it in terms of that, the other thing is that, and this is a downside to this act, is that, and I mentioned this, the 20 years that I acquired under the old Act, if I could have done that at any time, I'm locked into it at that stage, and that's now lost under this new regime. And again, there's still some uncertainty. If I had acquired at my 30 years against the state and 60 years for the foreshore under the old legislation, or certainly if I'd acquired it up to now, is the 30 years now running from 2009 again? Or am I adding it all up? And there's some debate over that. And again, I stand to be corrected if my misinterpretation of that is wrong. So what I will say, and again, Rosemary had alluded at the start, the Property Registration Authority of Ireland have some very helpful videos and practice directions and notices and mapping guidelines. Now, they're very detailed. And perhaps you might say that's why you engage a lawyer to deal with this, but certainly the videos are very informative and will give a very clear idea. And I think if you are looking at the right way, it's well worth looking at those, because certainly when you go into your solicitor, you might end up knowing more about what needs to be done than they will, and they will actually appreciate that in terms of that. And it might give you the opportunity, is this prescriptive right away, is that what I have, or do I have a right away under something else? And that goes back to my initial slides. Check who owns the laneway. Are you the registered owner? All of those things before you go down this route, or look at the land commission aspect. Next steps, what you need to do after this. Again, for most of you, this probably doesn't impact upon you. But I think you should check your right away, because the very important thing is that, say in 5 years' time, you decide to go and register it, and then you hadn't been using, or again, the landowner was under a disability and you didn't get your 12 years, and there could be problems there as well. So take a look at it and see, do you need to move this on? These are right away registered. If you need a right away, first thing to do is go to your neighbour and see, can you reach agreement with them? That's the easiest and cheapest and best thing to do. If you can't do that, you need to look at lodging a Section 49A application, which is your Form 68. If you're in serious trouble in this and it's going to cause you a lot of problems, or you're at risk of not getting this, you need to consider making a court application, and you will have to have your proceedings issued before the 30th of November. So there is a deadline in that, and courts are closed for August and September. Also, if you lodge your Section 49 application after the 1st of December this year, you go under the new Act. If you lodge your application and it's rejected, or it's already lodged and has been rejected and is rejected, and bear in mind the PRA have a 70% rejection rate of this type of application. If you don't re-lodge it before the 1st of December, or by the 30th of November, in fact, you have to make your application under the new Act, and all the rights you accrued are gone, and there will be some people who are going to fall through the cracks in that. And I think COVID probably hasn't helped. A query may have come back to their solicitor. Solicitor with COVID hasn't dealt with it. People say, well, come in when things change. And as you know, this has gone on a lot longer than we expected. And people have forgotten to go in and deal with the query, and has gone to the end of the solicitor's list. And the Land Registry then reject it because it hasn't been dealt with, or by the time you get around to it, you're too late. So if you have an application pending with the Land Registry or the PRA, check with your solicitor that they haven't raised queries, and that it's in and it's ticking away nicely in terms of that. Again, I refer you back to the resources provided by the PRAI. And again, on a more practical and on a more less legalistic basis, if you have any particular queries, ring the legal helpline. And as I said, they make up a large percentage of our calls. And people start most of their conversations will be on the helpline. This is very complicated, and it's not actually. Who owns the land left and right? When you come in off the road, what do you have to traverse? And in most cases, we can simplify it very quickly and put a bit of structure on it, and probably give a reasonable steer as to whether or not you need to go off and get this registered now, or is it so urgent that you don't? Is it not urgent and it could probably wait a bit longer? With the caveats that I have given. So I've thrown quite a lot at you there, and there'll be time now for various questions. And again, to emphasise, if you have any questions and you don't want to raise here, you can ring the helpline or drop me an email or come back through Francie or Rosemary or Jackie, and they will ask the questions on to me. Okay.
Thanks very much, James. We have Anne-Marie Carr and Isabel Lyons from the PRAI online. Would you like to introduce yourselves just to everybody before we start taking questions? Maybe Anne-Marie first.
Hi, good evening, everyone. My name's Rosemary Carr. I work in the Land Registry for the past 12 years, working in the legal services area. So I've dealt with prescriptive applications for a number of years, and obviously we're all very aware of the looming deadline. But I suppose I'd like to thank James there. He gave a very clear and comprehensive presentation and really covered everything. And again, I would just emphasise that for the vast majority of landowners, the new changes in the law won't see a major impact on those rights.
And Isabel.
Hi everyone, how are you? I suppose just again reiterate what Rosemary said. I worked in the Land Reg for 13 years, I think now, 13 or 14. Did work for a long period of time in the prescriptive easements area, and yeah, they can be there. The issues are, I suppose we'll go through them, or maybe people will have questions, but there are a lot of issues with them. Normally they can be overcome, so that's good news. And I suppose, yeah, there is a bit of pressure on at the moment to try and get registered your rights, if possible, under the old law. However, in saying that, and what James said and what Rosemary said, for the vast majority, it's not going to cause huge heartache, we hope. But yeah, there are going to be certain people who are impacted. So we shall see what happens in time, regards timelines or law changes or any of the rest. But for now, the PRA and the legal profession, the conveyancers, we're all acting on the basis, or going on the basis, that this law is coming into force on the 1st of December. So just bear that in mind.
And I suppose, look, before we open it up to questions, I probably would say I had a couple of queries myself about this in the past 3 or 4 months, and one of the guys that rang me about it said that he'd been in touch with his own solicitor, and he said the number of people on their roadway down to where he was living, the body of work involved in this meant that he couldn't give a commitment that he would have this work done for them by 30th of November. So from that point of view, we were looking, I think the legal profession are looking for a 6-year extension to this. Initially we're looking for a 2-year extension to it. And I suppose the one thing that this crowd does show tonight is that there's a huge interest in this. You don't get the number of people logged on a night like tonight when you could be outside in your back garden or probably doing work on your farm. We'd all be, if people weren't concerned about it. So look, we have a chat function here, which I think Jackie is going to try and man. If somebody had a question that they didn't want to put their name to and you type it in, Jackie will come to it at the before we finish up, and I think she's had a couple of queries emailed in as well. So the way we're going to run it is, I can see the function here myself now. I managed to figure it out while the meeting was starting. I can see the hands going up already. I'm going to give everybody a chance to answer one question.
Francie, just before you start the questions, just to emphasise on that point, the Law Society has written to the Minister looking for a 6-year extension on this, and that's partly to cover the issue that the Law Reform Commission is looking at the whole area of these prescriptive rights, and they're asking that at least that be dealt with before any final decision is made, and that's to be kicked down the road for another six years. And I know that the Irish Farmers Association have written to Darragh Breen, the Minister, and have asked at least for a minimum 2-year extension, and I've certainly raised the point with him. Will at the moment, and again, my understanding is that there has been no commitment to make any change. And I think, just to be clear, there will be a lot of talk. Asher, they'll sort it out and they'll kick it down the road, and people will just kind of hedge their bets and try not. I'm not sure that can be. I wouldn't rely upon that. I would hope that there might be an extension, but I don't think anyone should guarantee that there will be. I think that it's sorted. I think you need to proceed on the basis that this guillotine is dropping on the 30th of November, and you need to, if you do need to get your application in, you do it by then, or make sure that your application that has gone in is being processed by through the solicitor. And
James, just I don't know what happened. My feed here, but I was kicked out of the meeting, and I gather is the same. Did the same happen to others? Maybe not, but I can't see people who had their question. Jackie, I can't see who was asking questions. Maybe you can. If you can, would you call them in for me there, please?
So do you want to go for 2 or 3 at a time?
Go for 3 at a time, and I'll try and rejoin in a different way.
Okay, we'll go to George, Tom, and Adam. So we'll start off with George Byrne there first. George, you might just unmute yourself and I get everyone else to mute, please.
Hello, good afternoon, Francie and James and everyone there online. Just a couple of things. In relation to the access points to your land, if there is one way into the farm, does the form 68, is that still applicable? And I mean, in that I could be wrong on this, but I thought that if there's only one single point access on the farm, that form 68 mightn't be the actual application you need to use. And another thing is, and it speaks from experience, we had a prescriptive right-of-way register this year. It came through after we applied in August of 19. Sorry, I won't say we applied. That was the first time we started, and it was pushed back to us a number of times from the PRAI for various small things, but it all took time. And I'm just wondering, with this limit in November, or the date in November, what exactly suffices to have it in? Is it actually having the application in, having it sent back to you for further information? Does that mean you're still in or has been rejected, or is it outright rejection when you're finished your full application? It's a little bit vague, but I know it came back to us for further information on a number of times. So they're just two things I'd like to thank you.
Maybe we can answer that, Rosemary, I think.
Right, Isabel, or whoever, go ahead.
Yeah. So I suppose just to go on to the first point there, sorry, I think was it George who asked the question. He was wondering, was the correct route to use a Form 68 if you've only one access point into your land? you could use the Form 68, but as James pointed out as well, you have to be conscious or not whether or not this is actually an easement of necessity, which is something different and which is not suitable for the Form 68 procedure. Necessity is not registered by the Land Registry under the Form 68. So necessity is an implied right into a grant, and also it's where there is only one access point, is my understanding of necessity in general, and that would have to go into court in order to look to seek for that to be registered. I think, I don't know, James or Rosemary, do you agree with that aspect of the question?
Yes, as well, sorry, yeah, I would agree there. I mean, it's open to do a Form 68. It's open to consider, is it maybe an easement of necessity? That's where maybe it's landlocked or this is the only available access. Again, we don't register easements of necessity in the Land Registry, only if, I suppose, if you needed to go to court to confirm your right, if there was maybe some sort of dispute and then you get a court order to that effect, then that court order could be registered on your folio, on your property, and just, I suppose, to distinguish that from the prescriptive right of way. Again, as James had pointed out, sometimes maybe just direct communication with the neighbouring landowner and potentially executing a deed of mutual grant or a grant between the parties is another option to consider as well, if that was available.
Yeah.
James, if you want to add to that?
Well, again, you have to look at, I agree with what Rosemary and Isabel have said there, but again, you need to look at each application. And I'm not sure so much that is the one single point in. I mean, if you're given land and no right out, that may become a need for necessity. But if there's a clear laneway in and you maybe share half of it or something like that, and your normal acquisition over your 20 years or 12 years now should be sufficient to deal with that. But again, each case has to be looked at on its own particular circumstances.
And just before I go to Tom Byrne, just to remind people again that the meeting has been recorded and will be put up on the IFA website afterwards for anybody that wishes to access it. So keep your questions as brief as possible. Tom Byrne, please, followed by Adam Goodwin.
Sorry, did we didn't answer.
There was
the application
question.
Sorry.
I think George, a second question. I think it was just with regards to, he was saying, you know, if he lodges an application now and it's rejected by the PRA. So if that does happen and the application's not re-lodged before the 30th of November 2021, well then if it goes past that date, you get an application based on the new law. So obviously new applications being lodged now, there might be about it, if there's no issues arising, could be looking at a 2-3 month turnaround time, but obviously just to be aware that if the application is incorrect or needs to be rejected for further information, that will push it back or cause delays, or if there was any objections received by any of the notice parties. So there is that potential with the short time frame we have left that your application could be rejected, which means then from the 1st of December 2021, you would make your Form 68 application, but you'd be now basing it on the new law under the 2009 Act as opposed to the old law.
Right, fair enough. Right, Tom Byrne, followed by Adam Goodwin there, please.
Okay, thank you, Francie. Tarred Lane, mile long, the tar ends and the lane continues on for another 100 metres into a satellite field of mine. The piece that's not tarred is considered, and always has been considered, no man's land, but my neighbour is trying to farm a position on this piece of man's land, which the lane is basically on. If he gets adverse possession, could I lose my right away?
James, I'll throw that one to you there.
On there for a minute, just to be important.
So, sorry, James, we didn't hear you there. Sorry.
Yeah, no, sorry, Tom. I lost what you were saying there about the.
Oh, sorry. Right, the tar lane, the tar ends. The lane runs on for another 100 metres, and that piece of ground runs through what we've always traditionally known as no man's land. Okay, so now my neighbour is trying to get adverse possession on that piece of ground. If he was, and he probably has possession of that for the last 10 years at least, maybe 12. If he gets possession of that piece of ground, could I lose my right of way? Do I need to register that right away?
I mean, if you have a right of way over whoever the beneficial owner of it at the moment, if he's claiming adverse possession, I think your right of way continues with that, because you're there. It's no different if someone sold the land to him, he takes the subject to with the benefit of the right of way. So if he got registered on it tomorrow, you would say, well, I have my right of way here, and you can go and get your right of way registered. You know, there might be no harm in lodging the application, but you may have a challenge of who the owner of the land is, and there are certain ways around that, trying to deal with unidentified owners. But
there is no owner. There is no owner. Sorry.
Isabel, do you have any views on unidentified owners, which are challenging at the best of times?
Yeah. So yeah. That can happen, obviously, but we just can't ascertain who the owner is. So as you're saying, you're kind of referring to it, no man's land. So if it goes to the point of serving notice, we would direct you as the person looking for the right of way to erect a site notice and put an ad in the local newspaper applying for your right of way and showing the right of way as such on a map. So just what James was saying as well, the adverse possession part is independent and separate. It wouldn't matter really who owns it, as so. I mean, it's better if you do know who owns that bit of land, but it won't affect your right of way, or shouldn't, is probably what I should say.
Thank you.
Adam Goodwin.
Hi, good evening. If only half of Ireland's rights of way are actually on deeds, why was it decided to do this? It's a massive, massive nightmare to do this. It's like a gold rush for solicitors. In our situation, we have a right of way in existence for over a century with built hedges and drains and the whole crack. We've been trying since 2012 to get this through. It's been, I don't know, we haven't had any hassle with it, but it's just taking forever. And from what my understanding of what you're saying this evening is, if we get rejected by you, we're going to then be into the new law. And I've been struggling since 2012, chasing my solicitor and everybody else to get it moving. It's very inefficient, very cumbersome, and it's a very dodgy thing of the world of law to do this to us all, because it's very complicated and is ruining people's lives, as you will hear. Thank you.
Rosemary, I'll bring you in that there, please. If you'll mute yourself, Rosemary.
Sorry, yeah, can you hear me now?
Yeah.
Yeah, no, I mean, I understand your frustration. That's a very lengthy time to be trying to register right away. Obviously, as James had pointed out in his presentation, the purpose of the 2009 Act was to try and simplify and overhaul, I suppose, the law of prescription. It has brought problems. You know, they are acknowledged. I suppose what I would say with regards to, it's hard to comment on specific cases, but for the vast majority of cases, the change in the date and the timeline won't significantly impact your, I suppose, your standard right of way or your standard easement. And really, maybe the key change would be that it's the user period is now reduced to 12 years of user period, and the period considered is that immediately before you take action or make your application to the PRA. So I suppose unless, and I was pointed out in the presentation, unless there's, I suppose, specific factors to your case, maybe such as the owner of the servient land suffering under mental incapacity or disability, or if you're claiming the right against state land or foreshore, they're the areas that are a little, I suppose, grey or more uncertain. But with regards to your own application and trying to get it registered, I do understand the frustration of the length of time sometimes that these applications can take, and hopefully you get it sorted.
James, I'll bring you in there as well.
I would say on that, sorry, can I just add, I'm just wondering if that gentleman has an actual application. We can't talk about specific applications, but if he has an actual application in the land registry and it's dating back to 2012, you could certainly make contact, and we'll try and take a look at it as soon as possible, because it would need to be kind of moved on. I wonder, is the issue surrounding an objection or something like that, or are you aware of what might be?
Am I allowed to cut in?
Yes, Adam. Come on.
Yeah, thank you very much for that, Isabel. I think it's just been, because we were one of the first, nobody really knew the procedure to do it. And then because my deeds are in the bank, I think that because they're involved, somebody wrote to them and they didn't write back because nobody knew what to do. And it's just been, there's been no objections because it's there for centuries probably, but it's just nobody knew what to do, and it's just been hard to get things moving, that's all. But thank you very much. I'll chase it again, and I will keep in mind the November deadline, and I might come and chase you personally. But thank you very much, Isabel.
We do have a direct help, you know, an email. Maybe just send in the dealing number if you have it, and you know, we'll get it moving as soon as possible, because that seems a long time.
That's lovely. Thank you very much for your help. Thank you.
I would just add, actually, sorry there, Tom, if an application is in since 2012, it won't be rejected at this stage. It's only the newer applications that are subject to a rejection. So your application is in before the deadline, would proceed based on the old law, if there's an application pending.
That's still lovely. Thank you very much.
Adam, just to chime in on that, you mentioned that as gold rush for solicitors, there are certain types of conveyancing transactions that solicitors hate and loathe, and one is adverse possession, the second is rights away. There are very few solicitors, jump up and down for joy when the client comes in to say, I want to register my right away, because they end up being very protracted. To be fair, the PRA do raise a lot of queries, rightly or wrongly, and that, to be fair, as Rosemary and Isabel, that would be the perception, rightly or wrongly. And I say, most solicitors, they really wish right away would just go away. So I'm not sure that anyone sees it as a gravy train, but unfortunately, on the more complicated ones, and I think someone there mentioned 4 or 5, and we're dealing with one where there are 13 landowners to be dealt with. And I say that solicitor curses today his client decided to sell the land, because no amount of money will ever compensate you for the pain and the grief that causes you as a solicitor. It's just head wrecking. But unfortunately, I'm not saying that the work doesn't have to be done, but it is a challenge for a solicitor to deal with that and not end up charging quite substantial fees. But what, on the face of it, people say is quite straightforward. Actually, it can get very complicated, rightly or wrongly. I suppose, can I just put one question there, Francie, to Isabel and Rosemary? I'm conscious that there is kind of maybe not quite a formal direction, but where applications are now rejected rather than just queries be raised. I mean, if I lodge a deed of transferring a site tomorrow, and there's a query on it, you'll send it back and give me 21 days to sort it out, and then you reject it. But given the proximity of this deadline and COVID has caused backlogs in solicitors' offices, and people are uncomfortable going in to deal with their solicitors. And again, you're also dealing with a cohort of people, who might be in a slightly more vulnerable category from COVID. It might be useful if the land registry took a slightly more benign approach to that and allowed a bit more time and a few more warning letters before they were automatically rejected. But again, that's a suggestion I would make, and maybe Rosemary will convey that across.
Sorry, yes, no, James, no, that is a good point. I will feed that back, all right. I'm just aware, as me and Isabel both saying, we used to work several years ago in the Form 68 when they first started, so we're no longer directly involved in the area, but we can certainly feed that back in terms of the looming deadline.
Thank you.
Sean Sherman, please, if you unmute yourself, followed by Kathleen Maloney.
Yeah, Francie, thank you very much there for the opportunity to ask a question. My question is somewhat of a general question, Francie, if that's okay. And it has got to do with the duty of care of the land, of the right-of-way users. And if we take the example of where a landowner has a right-of-way for another person to get to their land, and there's always gates in place to prevent cattle from going to a public road. What is the responsibility, or who is the obligation for closing and opening those gates when the right way is being used in the act of preventing cattle from getting to a public road? And we say, where does the area of responsibility lie if cattle do get to the road? And we say, how does a landowner enforce, let's say, responsibilities on other people, on right-of-way users, to prevent this situation happening?
Right, Kathleen, Sorry, Sean.
Yeah, that's okay, Francie, that's fine.
Yeah, and Kathleen, we'll take your question as well, please, in an effort to try and speed it up. If you'll mute Kathleen, please.
I see Kathleen's just away from the camera there, so if you want to go on to the next one. Oh, Kathleen's back, yeah. Yeah, no, she's back.
Kathleen.
Sorry, my dogs took that moment to start barking just when it was my turn. So apologies if they start again in a second. My question was, if we have a right of way that's in a separate folio, my dad sold the farm and we kept a field, and there's a lane going to the bottom of the field, and we've the right of way the whole way down the lane and into the bottom of the field. There's a separate folio for that, and I presume registered in whatever way, but it's prior to 2009. Do we still have to register that again? But the right of way is actually on a separate folio to the land.
I'll go Isabel first on those two questions, if you like, Isabel.
Oh, okay. Sorry, sorry, Kathleen. Is there two? So you've two separate folios. Are both the folios in the ownership of yourselves? Sorry, you're on mute there.
Sorry. Yeah, I had to unmute again because of the dogs.
Oh yeah.
We have one folio is our own house and field.
That's called.
And then there's a separate. When the land was sold, the farm itself was sold. The rest of the farm. The farm was sold in two folios. One folio is the land and where the new people have built, and the second folio is the laneway, the full length of the lane. And we had right of way on that folio, on the lane.
On the lane, and there's written in a new folio now opened as such.
Well, that was done at the time of. Yeah, before when it was all being sold, like I'm in the home place with one field. When the rest of it was sold, my father unfortunately sold the lane, but kept right of way on it.
Yeah,
but that lane is actually in an individual folio.
Yeah,
because it was from a previous dispute. I don't know how that happened, but there are two folios to the land. One is purely the lane. Which sold was actually sold separate to the rest. There were two folios sold to the other people.
I suppose without seeing it, Kathleen, I couldn't give you an actual full categoric answer, but it sounds to me you already have the right of way registered, so there'd be no need to register the right of way for a second time. So
yeah, because it was prior to 2009, but at the time, is that okay? Because the solicitor did say to me back then that it was as strong a right of way as you can get because we were having some problems with access.
It sounds to me, Kathleen, that maybe when your father was disposing of parts of the land, that within his deeds he reserved a right of way back in favour maybe of the land he was retaining. So that is a strong right of way and it is registered. So again, as without commenting, without seeing it, but it does sound like the right's registered. There's no need to re-register a right if it was registered back in 2009. It seems to have been a right that was created by reservation in a deed rather than the prescriptive right here where you're making a claim for establishing your right as such.
No, it was held at the time of sale, so that's the one that's what prescriptive is. That's okay. Yeah, it was held at the time of sale.
Kathleen, what I might suggest is that you can very easily search folios now on landdirect.ie. It's one of the really impressive new bits of technology which was there for a while that the land registry have, landdirect.ie. If you type in your folio numbers, if you're in Kilkenny, it's KK and your folio number, and you can then pick up the folio beside it if you have that number. And if you click on that for €5, you'll get a plain copy of it. You can view it, and that will say if there's a right of way in favour of probably your father and his successors would be marked in that folio, not to deal with your concerns. And if that's registered, you don't need to worry about it again. If it's not registered,
that is on it.
Yeah. Well, then on that basis, you should be fine. Okay.
And James,
Sean Sherman's question.
Sean Sherman's question. James, on duty of care to a right of way.
No, I appreciate that. That's an interesting one. I mean, under the as a landowner, you have a duty to keep, unless you're on common areas where there's traditionally no fencing, but that doesn't apply to most of us. You have a duty to keep your animals in, and if the animals escape, because and you've adequate fencing and adequate stock-proof fencing for the type of livestock that you have, you will have complied with the act. Now, if somebody opens the gate, whether accidentally or maliciously, you have a reasonable defence to that, to assert that I had the gate locked, I had it closed, and somebody opened it and let the animals stray. So you are covered in terms of that. Now, you can certainly, as part of if you're granting a right of way to someone, you can certainly put a clause in that they will keep gates locked. And if someone is persistently opening gates, and this happens, it just neighbours being blackguards is frequently, and that's the nature of a lot of the calls I get about rights of way, is just the neighbours simply being difficult. And if they persist in doing that, ultimately, yes, you may need to go to the courts to get a court order directing that they keep the gate shut. If they are persistently, maliciously leaving it open, because there is a certain stage, if the gates are continuously open and you let your cows out into the lane and they stray, you may not be able to argue that you had adequate fencing in place because you knew your gates were consistently open. So there is a slightly grey area there where people persistently do something and you can't just turn a blind eye to it. And you may need, unfortunately, to take that very rather severe step of going to court to get a court order directing them to shut the gates and stop letting your animals stray. But if you can reach a mediated agreement or get a third party or maybe a local IFA chair or someone like that, that might be a better way to deal with it.
Yeah, so I suppose, Francie, if it's okay to come back there, maybe.
Very briefly, Sean.
Yeah, well, no, it's just, it's not to say that somebody is maliciously opening gates willy-nilly, but rather the act of maybe refusing to close the gates after gaining access to their property, and then cattle will eventually stray onto the road, maybe overnight or whatever, and then where does the case of responsibility lie in that situation?
Well, yeah, no, that's fair enough. And again, you have to look at each case as a merit. So, I mean, if you know the gates are being left open and you let your animals out, then you may be at risk. But that's where you need to contact them or get your solicitor to write to them and tell them that leaving the gate open could cause animals to stray, and they will be held responsible for having left the gates open and allowing the animals to escape.
That's fine. Thank you very much.
Matt Lone, if you unmute, Matt, please, followed by Tim. Both he can unmute there.
Can you hear me?
We can indeed, Matt.
Yes. I bought land 21 years ago, planted forestry, it's very successful, and had agreed right away through a neighbour's land for 1 kilometre. He's now rejecting that right away and said the right away should be elsewhere. What rights have I to establish and legally establish that right of way?
And Tim, I'll take your question as well, please.
Yeah, I was looking at Form 67 and I just see it says it needs to be witnessed, and I was just wondering, who does it need to be witnessed by? Does that have to be by a solicitor? Because I've got there's 4 or 5 different people I would have to get it witnessed by with the solicitor. And also, if your farm is still registered by deed rather than by folio number, can you still use the Form 67 and 68 to register your right of way?
Rosemary, I'll hand those two to you.
Sure, yeah, no problem. Hi, Matt. So just with regards to your right of way, you're saying you've had user for a period of 21 years or so, but there's now a dispute with the owner of the servient land. So just, I suppose, the options available to you to seek to establish a prescriptive claim would be, one, to come to the PRA, but again, that's where there's no dispute between the parties. So it would appear, if you went down that option, that you would make the application to the PRA, we would serve notice on the owner of the servient land, an objection would be forthcoming, and then we would end up looking for the application to be withdrawn. The alternative then would be to go to court to, I suppose, assert your right of way and claim your prescriptive right based on the old law. So in your scenario, then you would be conscious of the deadline looming, which is the 1st of December 2021. Just with regards to user period, you have 21 years, whereas post 2021, that user period will reduce to 12 years, but it will be the 12 years immediately preceding the date that you institute those proceedings. So I think in your case where there is a dispute, it would be, I suppose, recommended to seek, the advice of a solicitor as to maybe the best option for your particular case. Just to bear in mind, the PRA option is for no disputes really between the parties. And then, sorry, for Tim, for your question, the correct forms for the land registry, it's the applicant who wants to register the right of way makes it in a form 68. The form 68 is a land registry form, but it's an affidavit, and the affidavit is sworn by the applicant, the person who wants to register the right of way in their favour. When then the applicant must swear the affidavit, and that's witnessed, and it has to be witnessed by your solicitor or by a commissioner for oaths. When you talk about the form 67, I wonder maybe do you mean the form 69? The form 69 is what's the notice that it actually issues from the PRA directly. So the onus is on the PRA to serve notice on the landowners over which the right of way exists. So there's, it's not for you, say the applicant.
Sorry, the form 67 was the one where you could just go to individual neighbours and ask them to sign it, to where they would grant you the right of way over the laneway.
To grant the right of way. Oh, sorry, I completely misread you there. Then sorry, I thought you meant with regards to the prescriptive one. So yeah, I mean with that, then they all that's a deed of grant, so it can be witnessed by anybody, and if they state their occupation and identity. Isn't that it as well? Sorry, apologies, I completely picked that up wrong. And sorry.
Yeah, so the form 67 is like an actual grant, so that's where you've no dispute and all the rest. And did you also ask him, can you use the procedure if it's unregistered land? Was that yourself?
Well, our farm is still registered, is still sort of done, but has been passed on by deed rather than, and doesn't have a folio number, whereas all my neighbours' farms, which cover the laneway, are registered.
That's something to mention indeed, that we can only register a right when the dominant folio is registered as well. So for you to get your registration completed before the deadline, you'll also have to register your farm. So you'll have to go and seek for first registration of your farmland, and then if you're looking to register your right of way, then it'll be attached to your folio. That would be a bit of an issue.
The farms that cover the laneway are all registered, that comes right up to the edge of our farm, are registered. So would I need to register our farm as well?
You would, because you're looking for it in your own right. So the other farms around you won't, yes, that's great that they are, as regards, they're going to be the servient tenements if you're going to be traversing over other farmland. But no, your own farm would have to be registered in the first instance.
James, have you anything to add to that briefly?
Right. It's not a huge problem for landowners because most of the land is registered in the land registry. The second line, where one often least expects us is registered in the registry deeds. I think that's what Tim has there. Unfortunately, he does have to make an application for first registration, which is not that complicated, to be fair, against an affidavit, detailed title history and purchase, and your solicitor will be well capable of doing that. But that has to be done before you can make an application to register the right of way to your land. It has to be registered land before you can do that.
Right. Eamon Brennan, if you unmute, followed by Pat Murphy, please. Unmute too.
Thanks, Christy. I'm sure you can hear me there.
Yeah, can Eamon? Yeah.
Okay. I'm on the other end of it. Well, we have a right of way, I believe, that is properly registered on a folio and shown yellow across the map. but unused for a long, long time. Is that okay because it's registered shown on maps that we don't need to worry about maintaining it to keep it, or could that lapse through use?
James, I'll give you that one.
Yeah, no, sorry, Eamon, are you saying that you have a right of way over laneway that you haven't been using, or your neighbours have a right of way over it, is it?
We have a right of way over a laneway that is used to a point, but the final leg connects to our land and it's heavily overgrown. It has been used for decades, but it's there if it's ever needed, and it's shown on maps. I'm wondering if we make no attempt to use it or maintain it, could it go? But it's not. It's not across a field. It actually is a laneway that's not used.
I think any solicitor would say to you that it would be prudent that you exercise your right over the laneway, so there can be no doubt about it. I mean, we've seen affidavits where there's disputes over the right of way, where we say you haven't used it, it's overgrown, there's large oak trees growing down the middle of it, and they still come along and say, oh, well, sure, I remember going down there, I go down there once a year to look at the old house, or I go down there with my grandmother picking blackberries. And your problem is you can't say that you didn't see them use the laneway for 24 hours a day, 7 days a week. So I think it would be prudent to avoid a row in the years to come, because at a certain stage, you know, if it gets so overgrown, some courts look at it and say, yeah, it's not used, nobody's used it, so the right of way has been extinguished. Now, it's not an easy thing to do because the courts are reluctant to do that, but I think it would be sensible to go off and you know, trim the laneway, or you know, even drive a tractor down to the end a few times a year, just to keep it live, so to speak, so that you're not going to have a row with the owner of the land in 10 or 15 years' time as to whether you did or didn't use it.
Pat Murphy.
Hello, everybody. Thank you very much for this facility. My problem is my father, how should I say, the right of way was always the only way into this farm that I'm speaking about. And the farmyard and Redden were way out in the middle of the farm, which is now obliterated. I mean, the house is obliterated. My father bought the place, bought the farm in the 1930s when I was a kid. I inherited the farm on my father's death, but like the previous speaker, it was a narrow laneway, and when machinery got big, it wasn't so suitable. I was given permission by the present owner's father to widen some of it, which I did. I removed one fence, but the part up near his dwelling was kind of wide enough. A horse and trolley was able to take hay out through it, which I did myself as a kid. So I left that alone. Now, I had a truck coming in there about 10 years ago, and the truck was brushing both sides of the lane, and my neighbour stopped him because I was putting muck onto it. So now I want to register it, but I was afraid to approach him during COVID in case his hack was out. So I didn't. But like listening to this program tonight now, I feel I better start off first thing tomorrow morning and approach him. My local land registry office gave me a form 67, which I still have here for about 2 months, but I intend to call to see him now almost right away and ask him to sign the form. Perhaps you could comment on
it. Isabel.
Yeah, Pat, I think that's probably prudent, actually, the Form 67 route initially. It does sound to me, just when you said that, you know, he stopped the larger truck going up the lane at that time. See, over time, as you know yourself, the uses of the rights of way, you know, particularly in rural areas, have expanded, I suppose, but as in a horse and trap might have got up there in the 30s and 40s and 50s, but now, as you say, the machinery is all bigger. So certain rights that are just agricultural rights, you know, they mightn't exactly translate into being rights for huge heavy machinery. And I know that the Serbian property owners, that's where they have a big concern if they think there's going to be this, you know, onslaught of a lot of machinery up and down their private laneway dwelling, you know. So now that's not something the land registry gets involved in. So it kind of sounds that perhaps in the first instance, if you go with the Form 67, whereby you approach your neighbour and see if you can agree on the right of way being in existence. Because if you go directly to the Form 68 and do it by prescription, he may object on the basis of the use of the laneway. So I think you probably should start off with maybe contacting your neighbours is what I would suggest in that particular instance. Yeah.
James, do you want to comment on that?
Sorry, yeah, just very briefly, if you can get your neighbour to agree, that is by far the best way of doing it. It's quicker, cheaper, and much less hassle. But just bear in mind, it's not just him signing the form, you need to get the land registry approved map marked out showing the right of way. And again, because the laneway is wider than, I think you've widened it a little bit in place. You need, if they're lifting it from a land registry map, it may not show that exact width. So you may need to get a surveyor just to mark it out and make sure it's done properly. So maybe you might approach him first and see, does he agreeable, then instruct your surveyor. But if he's not agreeable, or it's been difficult, or just doesn't, like lots of people, he's not disputing it right away, but won't sign the piece of paper, you're going to need to get that map done anyway. But if you can do it that way, 100%, that's the way to go.
And Anne-Marie Ryan.
Hi, Francie, can you hear me?
Yeah, can indeed.
I think my question is for James. I'm not sure. I'm just querying, what are our options where a person on the right of way is impeding our access, although we have legal right of way, and the impediments are through obstacles, namely gates thrown on the right of way, bars, clay, various things. And also, what happens when that person impedes our access for animal movement or welfare issues? And what is the role of An Garda Síochána where that access is impeded?
Yeah, and this is all too common, unfortunately. At the end of the day, I assume he's not disputing you the right of way. It's just been difficult and very quite awkward. And if he's interfering with your right of way, the ultimate remedy of applying to the circuit court for an injunction to prevent him interfering with your right of way. And again, I'm assuming, and that applies even if your right of way isn't registered, but you've acquired it by over the 20 years. And if I think you actually said it is registered. So if it's registered, you've been using it. That unfortunately is your remedy, is ultimately to go to court and threaten it. Now, just very briefly, if you go to court and it's fought fully, it's going to cost an arm and a leg. Now, if someone has just been a blackguard and it's not costing them anything to be difficult, often a solicitor's letter or even issuing the proceedings, which in the overall cost, I'm not saying it's cheap, but in the overall scheme of the cost of proceedings, it's quite good bang per buck effectively. That might give them second thoughts, and they bring those proceedings to their solicitor, and the solicitor says, they're going to win this, it's going to cost you an arm and a leg, and you're going to have to pay me up front. That might put some manners on them. The role of An Garda Síochána is, it's a civil matter. It's trespass, and unless people start physically threatening each other, assault or waving shotguns at each other, where that becomes a public order or an assault, they don't want to get involved. Now it's interesting, I've had a couple of calls recently where people have been taking down gatesway or fences that were put in rights of way, and the guards have actually started talking about criminal damage. And I have one case that I'm aware of where the client is being prosecuted for criminal damage for taking a gate off a right of way that he said was put on the right of way, interfering with it. And so, surprisingly, I am surprised that the superintendent is prosecuting for criminal damage. But just merely blocking or interfering with the right of way is seen entirely as a civil matter by the guards, and they do not want to get involved. But if they see that it becomes, if there's assault or threats or intimidation, they might start getting involved. But it's never that simple.
Francie, can I come back in there?
Briefly.
1 second.
Very briefly, Anne-Marie.
Sorry, now I don't want to hog it, but to what extent do what's called assault? Does somebody coming down verbally abusing you? Does somebody coming down with a hammer in their hand? does somebody coming along the right of way, where they have parked their Jeep, impeding you leaving the field with a trailer load of animals? Like, how far does this go, and to what extent does it have to go where the Gardaí are actually involved, and this is beyond accommodating? Now, and the Gardaí have been very accommodating to us in this situation. I have to commend them 100%, and I don't want to name anybody or name any superintendent in this situation, but they have been very accommodating. But like when the person is putting impediments like obstacles of barrels, clay, using his digger to prevent us leaving our land,
well, I think
with a trailer load of animals in,
yes,
we'll get James to address. We'll get James to address that.
I can understand that. I mean, obviously, it's not for you to make a formal complaint, right, if you feel it, and it's also not just physically hitting, be putting fear of that. So it may be up to you to decide to make a formal complaint to guards about assault, and they may or may not investigate it. They have a certain reluctance to get involved in this, or it often doesn't work out the way that you want, and it doesn't immediately solve the issues and often inflames the issues. But on a more practical basis, on the other side, in the civil side, putting barrels in, blocking you coming out, they're interfering with your right of way. And absolutely, if you issue court proceedings on that information you've given me, the court will grant an order directing them to stop interfering with the right of way. And ultimately, if they persist in this, you can bring an order for attachment committal, and they'll come back to court for breach of the court order, and they can be jailed by the court for breach of the court order. So there is that kind of other remedy at the other end. But unfortunately, you just have some people are absolute blackguards, and they can be very difficult to deal with, even on the civil. They just don't care, and that is a problem. But at some stage, because they're blackguards, so if you stand up to them and get the proceedings out, that sometimes does cramp their style a bit, and it does often bring them back, or in some cases they might negotiate and try and just sort it all out. But there are some people out there who just don't care and are just obnoxious neighbours.
Look, I'm conscious that we're on this. It's heading for 10 o'clock. I see there's a couple of hands up that have been in already, and I'm going to move on from me. I see John Dolan. I'll take the last question from him, and there's a number of questions into Jackie written on the chat, and we'll deal with them, and we may wrap it up then. So John, if you unmute yourself there, please. John Dolan. If you unmute, John.
Yeah, can you hear me?
We can hear you, John. Yeah, go ahead.
This right away is say belonging to us for maybe 100 or 150 years anyway. But the right of way is up to a farm, and there's one other neighbour uses it also. And lately, say back, I asked about maybe 2-3 years ago, this man is after this other neighbour is claiming now that he has the right of way. He's claiming the right of way on it, and he's also claiming that it was on his deeds on the field that he bought, say, but was never taken off it was never taken off the deeds, they say. That's what basically it is like. So basically what it is one of the neighbours next door to us, he's claiming the right of way on the lane, and he claims that back, maybe 70, 80 years ago, whenever the field was sold, the right of way was on that field. So
James, I'll go to you first on that.
Well, if the right of way is there and is registered in the folio, they have the right of way. And just to be clear, a number of people can use a right of way. So you may have a right of way over a neighbour's land, other people may have a right of way over that laneway as well. And I hope I'm addressing the question right there. But if your other neighbour's using it and says they have a right of way and it's registered, well, you need to look at their folio and confirm that. And if not, they may have acquired a right of way on a prescriptive right of way, and they can either register it under the old system or under the new system.
And is there any way now, is there any way we could be doing over a right of way, considering we're using for the last 140, 150 years, if you know what I mean? It goes up to the main bog as well.
So you've acquired your right of way over that and under the old Act. Bear in mind, in a few months' time, it will only be 12 years that will count, not the 120 years. Just be clear on that. But the fact that he may have a right of way over the laneway is an entirely separate issue for him, and he can't oust or interfere with your right of way.
Right.
Isabel, do you want to come in on that there, please?
Just exactly what James is saying. I think if I understand the question as well, that like certainly more than one person can utilise the same right of way and have it registered in your favour over the part of the laneway that you're using. So yeah, there shouldn't be an issue just because your neighbour has it. You're saying you've the same right of way over whoever's land it is, the Serbian property in the first place. So yeah, they're independent. Your right of way is independent of your neighbour's right of way.
But I wonder, would you have any right at all, considering he's claiming that the right of way wasn't taken off of the folio of the land he's on, like he's claiming that's what he's claiming. So he's claiming that the land he has now, and he bought off of this crowd like back maybe 70, 80 years ago, that it wasn't actually taken off off the lane, like, you know. He's claiming that he's claiming the lane was actually on his field. Don't you understand, mate? That's what he's claiming.
Oh, so you're actually going over his field to use your right of way.
We're going up the lane. We're going up the lane. We're going up the lane the same as we always did. And my uncle and my father all belong to him. But what he's claiming is that he actually owns the right of way.
He owns the land over which the right of way you're using.
He's claiming he owns the lane, which is the right of way.
That's still, yeah, so that's okay that he's the owner of it. So we would, sir, if you wanted to register it, you could do it a few different ways. I don't know if you
Could you answer that question maybe, or give an opinion?
Yeah, sorry, my apologies, there was a misunderstanding on my behalf. If he's now asserting he's a registered owner of the laneway, rightly or wrongly, you still have your right of way over it. So it doesn't matter per se who the registered owner is, you have your right of way. And that this is an issue between the landowners as to who owns the land. But if he was to successfully show ultimately he is the registered owner of that bit of land, you still have your right of way. So if he attempted to stop it, you would say, don't care who owns this, I have a right of way over this stretch of ground. Whether you or the other person are there, I still have my right of way.
Jackie, there was a couple of queries through the chat, and you had a couple of queries emailed in. Maybe if you want to go through them.
I'll go to the email there first. It's just two questions there. The first one is, I own a semi-derelict house and land at the end of a lane where there are two other private residents on the lane. Do I need to register the right of way? And if I don't register the right of way, could there be a situation in the future where I would have to ask for permission to access my property via the lane? That's the first question.
Rosemary, I'll give that one to you.
Sorry, now I'm not sure if I caught all of the question. Could you repeat it, Jackie? Sorry.
Yeah, so I own a semi-derelict house and land at the end of a lane where there are two other private residents on the lane. Do I need to register the right of way? And if I don't register the right of way, could there be a situation in the future where I would have to ask for permission to access my property via the lane?
Okay, so I mean, it appears to me they're saying they've had a long user of the right of way, which is an application based on prescription. It's open to a landowner to make that application to register that right. Just one of the key changes brought about by the new law coming into effect on the 1st of December 2021 is they've introduced a new provision that means that if there's a period of 12 years of non-user of your right of way, that then it may be extinguished if you haven't used your right of way. So I suppose it would be advisable to register your right of way to prevent, I suppose, a future problem with maybe different owners down the road a couple of years' time who may have an issue with the right of way. In that case, may make it more difficult. So I think, I mean, it's just if you have acquired a right by prescription, it will be prudent to make an application to the PRA to register it. It's not compulsory; you don't have to register your right away. But I suppose it's important to be aware that there could be some implications if you had a period of 12 years non-user following the 1st of December 2021, then that right away could potentially be lost. So there is that consideration to have in the back of your mind.
Agree, James?
If there's any doubt about it, exercise is registered. If there's a prospect of not using it, and this keeps coming back to, you may have acquired it under the old Act, but if you haven't been using it for 12 years before you make your application, say in 3 years' time, you may lose out on it. Now, there is an issue about how someone says you haven't been using it, as we mentioned before, but I think this ties in with a couple of the other questions that were raised. But if in doubt, go register it.
Okay. The second question then that came in by email is, I own the lane and land where there is a private residence at the end of the lane. They have asked me to sign a right of way. I have verbally said, yes, you have the right of way, no problem, but I do not want to sign a legal document. Do I have to sign it, and what are the consequences if I refuse to sign it?
Just very briefly, there's no obligation on you to sign that, and it'll be the form 67 that Rosemary had been referring to before. There's no obligation on you to sign it, and your neighbour can't force you to sign it. And if you don't sign it, they can make the Section 68 application, and that will take its course. And if you object to it, they can go to court. But if you've acknowledged you have it, there's no reason you shouldn't sign it. What I might often suggest in those cases that you say, look, I want my solicitor to look at it. If you pay a couple of quid towards their reasonable fees, so I'm comfortable with that, and I think there's merit in that. But no, you don't have to sign it, and they can do the Section 49A Form 68 application. So you're not stopping them registering the right of way if you choose not to sign it.
And Jackie, have you a couple of others there briefly?
There's some on the chat there now. Just give me a second.
We'll
Some of them seem to have disappeared there. But anyway, what is the procedure to register a right of way through Quilcha Forestry?
Any other query?
Hang on. A question where the red line is located on a map. One is in the centre and other is in the ditch by the Land Commission. A neighbour is claiming ownership of land. So where the red line is located on a map.
Isabel, I'll give them two to you. If you're mute. If you're mute, Isabel.
Yeah, sorry, I was hoping you wouldn't give me those questions. Sorry, come back to me. The first one was about going through Quilcha land.
What is the procedure to register? Yeah.
Well, it will be the same procedure as any other land. We would serve notice on Quilcha if it's going through, if the servient property traverses over Quilcha land, we would serve notice on them. So the procedure as regards the Form 68, which is what we're mainly talking about, the prescriptive application, is the same as it is for any other type of servient land. Now, again, you have to bear in mind the timeline, so get it in before the 1st of December. Is Quilcha land, is that state land? Would that be referred to as state land? Probably.
James.
Not entirely sure.
Yeah.
I mean, it used to be, but not sure that Quilcha is now a semi-state body. It's not sure that it has same rights.
Yeah.
But generally, I mean, if you've acquired a right through it, Quilcha, to be fair, have their moments. They can be a bit difficult to deal with. But I mean, if it's there, I think the first thing to do is to approach it and say, I have a right of way. I want to register it. You sign that form.
Yeah, we have seen quite a number of them in over my time doing the Form 68, so would have registered a number of applications over Quilcha land in the same manner as we would any other servient property.
And the one on the red lines in the map, Isabel.
Sorry, I have. Can I get that again? I don't understand what
it's not overly clear. It just says a question where the red line is located on a map. One is in the centre and another is in the ditch by the Land Commission. A neighbour is claiming ownership of lane.
I'm sorry. I can't even hazard a guess to that answer, to be honest. I don't know what the question is really. Do you, Rosemary? Sorry, or James? No.
Yeah, I mean, just very briefly, I mean, first of all, the maps the red lines are not indicative of the actual boundary in the land registry. We're very clear about that. And I think that even goes back to the old days when you had a red line outside. If you scale that up, that was 15, 20 foot across. So it's indicative, but it's not definitive proof of the boundary. And yes, there's always this issue between the Land Commission lines and the land registry lines, and there's often could be a digitized mistake when they scanned all the old maps. It could have been a mistake there, and it's important to look at all of that. So there's no definitive answer as to whether, there's a lot of facts and history and who used the laneway, what it was used for. You may need to go back to the old maps and work your way up. So unfortunately, I don't think anyone here can give a definitive answer which line is correct. But there's quite a bit of work would have to be done to come to that decision.
And finally, I'll take one more question from the participants. I see Henry Guest. If you unmute Henry, you can ask your question.
James, if you use the right way for 30 years, use it maybe 3 or 4 times a day, and intend using it in the future, is there any need to register that right away?
James.
Yeah, no, thanks for that, Henry. That's that I think it comes back to technically no. There isn't, because you have that right away. The only problem is the person over whose land you have that, they become sick, and then you try and register it in a few years' time. You haven't done it for 12 years beforehand, and that is another glitch in this act. Under the old legislation, once you hit your 20 years, you were fine, but now you have to do 12 years before you make the application for registration. So in theory, you could be using this for 100 years and then don't use it for 5 or 6 years, and you haven't used it for the 12 years before your registration. So on balance, yeah, I mean, you're one of the people who said this, you shouldn't be getting worried about this, just go off and keep about your business. But just to mark your cards that if there is keep an eye on your neighbour and see what condition they're in. But yeah, if you've been using it that long, if you can reach agreement with your neighbour to sign that form 67, which is just the notice giving each other the right way. If you could do that, that's the quickest, cheapest, and easiest way to do it, and it avoids complications, down the road. Again, coming back to the very first thing I said, why do you do this? It's if you want to sell land or transfer out of site or charge some of your land or something, the banks or the purchasers or your children's lenders, if they're raising one of the sites, will need to see the right of way registered. Now's the time to do it, not when the gun is to your head. So, and
James, if your friendly neighbour refuses to sign the Form 67, where do you sit then?
You go off, you fill out the Form 68, next form over, fill that up, it's the affidavit, that's got the whole history, and you lodge that in the land registry.
And if that's contested, then where do you go?
Circuit court, bring an application.
Yeah. Aidan Brennan, finally, I'm going to take the last comment from you there. I see you're looking to get back in again.
Yeah, no, it's just the question. The lane was earlier on where we have allowed it to be overgrown. It is on the land registry in yellow, but are we as well to register for the exact reasons you're talking about? Or once it's on the land registry, does that count as registered for purposes of this?
Yes, it does. But you just need to be careful you don't lose it by non-use.
Sorry,
but the reaction I need to make is to use it. I don't have to do any paperwork. Just use the lane, that's enough.
Yeah, just go down, but you don't walk up and down, start picking the blackberries when they come out in season, and just keep encroaching back onto that laneway and making it yours.
And Henry Mooney, look, just back in briefly now, Henry, if you want. Unmute. Unmute, Henry.
Yeah. No, James, what's the number of that form you said, 67, is it?
Yeah, that's the form where you approach your neighbour. It's the Form 67. You get it on the PRAI website. They're just type in, actually you Google Form 67 Land Registry, it'll pop up and you can complete it. But you can really emphasise it needs to be done properly because it'll be rejected, and you need to have the right map. And I can't overemphasise that because we keep getting things, I mark up my own map. That's not the maps you use, your day-to-day stuff, are not the approved maps. They have to be marked and they have to have, there's numbers on them that give the triangulation of it. I think you stand to be corrected, Isabel, on that. That's my understanding what those particular numbers are. So, but that is where it is. And if you print it off and look at it, it might make you more comfortable approaching your neighbour in terms of that. But you need to have it filled correctly and have the right map attached to it.
Now, look, final 2 questions, and that's it. I see people who hadn't had their hands up earlier on. So, Adrian Harper, if you unmute briefly, Adrian, and Pat O'Toole, followed by Pat O'Toole. If you unmute Adrian, please.
No, I have no questions. I just pressed the wrong button here.
Right, no bother. Pat, have you a question?
Yeah, Francie, just a quick one. Look, thanks to everyone for really informative meeting. If you don't know who the registered owner of a property that you may be trying to establish a right of way on is there a search facility? There once was, but is there a search facility where you can ascertain who the owner of a piece of property is?
Rosemary, I'll give that to you.
Hi, Pat. Yeah, I mean, I suppose the first port to call is if you either know the owner, that's great. If you don't, you can look up the land register, see if there's a folio and get the current names and addresses. If there's no registered folio, you could carry out its Registry of Deed searches. I suppose that's carrying out searches against, unregistered land. It might throw up some names there. That's what the PRA will look for. They'll look for, I suppose, efforts and searches to be made to try and ascertain who the owner is, even just if you establish it's through local knowledge or personal means. Failing that, then we go down the road of an advertisement in the local newspaper or a site notice to be erected at the entrance to the laneway. So that's really it. I suppose it's just really through looking through our Land Direct or the Land Registry folio, or carrying out some Registry of Deed searches, or just local knowledge.
Agreed, James?
Absolutely. Landdirect.ie, Pat, is just go on to that. And if you have your own folio number, you can drop that in, and then you can see is the land beside it registered, and you can get the name from that. It's actually, you'll end up going down rabbit holes looking at all the neighbours' lands on it. It's a great facility, so it is.
Look, thanks very much. I'm surprised you're not on a combine, Pat. But anyway, look, we'll call it off at that for tonight. I'd like to thank Rosemary and Isabel, obviously, from the PRAI for coming on, and James, obviously, as well, James Saints. This came about through a number of queries into the Wexford and Wicklow office. And Jackie said to me, would we run what would we do? And I said, you run a meeting in Wexford and Wicklow. And she said, no, I think we should run one for South Leinster. And, Dawn and herself put it together tonight. I was taken aback by the number of people that logged on, I have to say. And that is an indication of how concerned people are about this. I'd be astonished if there's not some leeway in terms of the timeline at the end of November to give people a chance to sort this, maybe combined with some sort of a campaign or some sort of an information program like this to inform people of it, so they can get their ducks in a row. And maybe, I think James alluded to it, maybe there is a need to look at the legislation again to get it 100% right if we're going to try and sort this out. And look, to Donal, I'd say, I think you're leaving us probably towards the end of the month. You've been a great addition to IFA when you've been here, and the very best of luck to you in your travels. And look, it is a bit buyer beware after listening to this tonight. I think there's as many questions unanswered as, well, maybe not unanswered, but questions there still that people have. And I know the Farmers Journal have had numerous queries in about this as well. And I'd be amazed if maybe we'll run another one of these, or I'm sure they might run something. But I think there's a lot of questions to be asked between now and asked and answered between now and the end of November on this, and we'll see where it goes. So, Rosemary, do you finally want to say anything before we close up? Rosemary.
Yeah, basically just to, I suppose, concur with everything you said there, Francie. You have summed it up quite well. To say thank you very much to Rosemary and to Isabel and to James Staines. And it does just show the concern that's out there, the amount of people that logged on tonight, as we said, with the lovely evening, that there are a lot of concerns, there are a lot of questions, there are a lot of queries. And I suppose the word would be to try and act on the side of caution and to go ahead and look into things and get them registered and go about it, at least the system in place, and to, I suppose, push with your solicitors or push with your application and just, you know, get it in there and get it moving. Even if you think, at least get talking to your neighbour and just clarify that things are in order, that it's so much easier with the old legislation rather than with the new. I mean, we would be hoping for some kind of an extension or a deadline or something, but at the same time, we have to presume that, you know, lastminute.com is going to come at the end of November, and we have to work to that deadline at the minute. So thanks very much for your time and effort. It's a late evening, and well done, everybody.
And thanks very much, Rosemary. Look, to everybody, I'd say if anyone online has a query, if they get in touch with our local office, we'll try and push them in the right direction. Certainly, James, and the legal helpline is there to be accessed by any of our members that need it. And look, I know we often talk about farm safety when we're finishing up these meetings and ask people to keep it in mind, but it happens to be Farm Safety Week as it is, and it's a very, very busy time of the year. I was down in Tullow today, and look, the amount of work that's going on farm, particularly that part of the country and down to where Pat is and further south, harvest now, it's, you know, it's unbelievable really. So I'd just say to people, you know, take a step back before you get going and look at where the pitfalls might be and try and farm safely. And once again, thanks to everybody for coming on. If you have any issue that you want raised, get in touch with us at local office level, and whoever it is, Jackie, and push it up the line to me, or we'll try, and Willie, Joe Kelly, and Donald there in the Farm Business Committee, we'll try and get it sorted for you. So, thanks very much, and good night, everybody.
Thank you. Thanks. Good night.
Good night, Francie.
Thanks, Francie. Thanks, Francie.
Okay, good night, and thank you very much.
Thank you.
Thanks, everyone.